Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 1 and 2 on the speed of 90 words per minute. Start. Despite the conclusion recorded herein above, we are of the view that in the facts and circumstances of this case, there should have been no difficulty whatsoever for the High Court to have exercised its judicial conscience for invoking the power vested in it under Section 482 of the CRPC. From the narration of the facts recorded above, it emerges that even though the respondent complainant in his complaint dated 6/7/1993 adopted a clear and categoric stance that his daughter Dr. Monica Thapar had been poisoned to death before the additional sessions judge, Delhi, the respondent complainant ventured to suggest that the appellant's accused had strangulated her. The additional sessions judge, Delhi, summoned two of the doctors who were members of the medical board which had conducted the post-mortem examination and sought clarifications from them. He also recorded the statement of one of the said doctors. The additional sessions judge thereupon ruled out the plea of strangulation. When the respondent complainant himself was uncertain about the manner in which his daughter had allegedly died, the High Court should have viewed the matter keeping in mind the likelihood of the hurt caused to a father who had lost his daughter within 1 year of her marriage. The matter needed to have been evaluated on the basis of one of the parameters laid down in State of Haryana and others versus Ramlal and others 1992 1 SCC 335, whether the criminal proceedings initiated by the complainant were actuated by malice and ulterior motive for wreaking vengeance on the accused with a view to spite him due to some personal grudge. There is yet another reason emerging from the facts of the case which needed to be kept in mind. The respondent complainant had continued to represent before the SDM Delhi that he would produce the mother of the deceased, who knew the facts best of all. Despite that, the mother of the deceased did not appear in the inquest proceedings to record her statement, even though a number of opportunities were afforded to the respondent complainant to produce her. The permissible inference is that he was himself not privy to the facts. The fact that the mother of the deceased had not appeared to record a statement against the appellant's accused has to have some reason or justification. Would a mother who believes that her daughter had been poisoned or strangulated restrain herself from recording her statement despite the persuasion of her husband? The instant factual position has been recorded herein above not for the sake of determination of the present controversy. In a factual situation not as clear as the one in hand could be taken into consideration by a high court for recording its satisfaction on the parameters formulated above. For the reasons recorded herein above, criminal proceedings against the appellants accused are hereby set aside. The order of the High Court is accordingly also set aside, but on grounds different from those taken into consideration by the High Court. The instant appeal accordingly succeeds. A reading of the impugned order shows that the learned single judge did not find any jurisdictional error in the award of the labor court. He also did not find that the award was vitiated by any error of law apparent on the face of the record or that there was violation of rules of natural justice. As a matter of fact, the learned single judge rejected the argument of the corporation that termination of the appellant's service falls within the ambit of Section 2 of the Act and expressed unequivocal agreement with the Labour Court that the action taken by the managing director of corporation was contrary to section 25G of the act, which embodies the rule of last come first go. Notwithstanding this, the learned single judge substituted the award of reinstatement of the appellant with compensation of rupees 87582 by assuming that appellant was initially appointed without complying with the equality clause enshrined in Article 14 and 16 of the Constitution of India and the relevant regulations. While doing so, the learned single judge failed to notice that in the reply filed on behalf of the corporation before the Labour Court, the appellant's claim for reinstatement with back wages was not resisted on the ground that his initial appointment was illegal or unconstitutional and that neither any evidence was produced nor any argument was advanced in that regard. Therefore, the Labour Court did not get any opportunity to consider the issue whether reinstatement should be denied to the appellant by applying the new jurisprudence developed by the superior courts in recent years that the court should not pass an award which may result in perpetuation of illegality. This being the position, the learned single judge was not at all justified in entertaining the new plea raised on behalf of the corporation for the first time during the course of arguments and deprive the appellant of what may be the only source of his own sustenance and that of his family. Another serious error committed by the learned single judge is that he decided the writ petition by erroneously assuming that the appellant was a daily wage employee. This is ex facie contrary to the averments contained in the statement of claim filed by the workman that he was appointed in the scale of rupees 350 to 525, and the orders dated 3/10/1986 and 25 to 1987 issued by the concerned executive engineer appointing the appellant as work munshi in the pay scale of rupees 355 to 525, and then in the scale of rupees 400 to 600. This was not even the case of the corporation, that the appellant was employed on daily wages. It seems that attention of the learned single judge was not drawn to the relevant records, else he would not have passed the impugned order on a wholly unfounded assumption that the appellant was a daily wager. It is true that in the writ petition filed by it, the corporation did plead that the dispute raised by the appellant was not an industrial dispute because he had not worked continuously for a period of 240 days.